This conference will now be recorded.
Good morning. I'm Stephanie Schneider, board certified elder law attorney, and I welcome you on this Friday, April 17th, 2026, to my webinar, What Personal Injury Attorneys Need to Know About Elder Law Issues, Lions, Tigers, and Bears, oh my. And today we're going to be talking about the top 5 issues that I see arising, whether it's in the context of a personal injury case, a medical malpractice case, or even a wrongful death case. And my goal for today is to give you some practical tips to help you ensure that the litigation proceeds in a timely manner and doesn't get delayed by not having thought about these issues. And one of the themes you're going to hear this morning is the idea of collaboration, because to successfully complete a case, it takes not only your expertise or mine, but the expertise of other people that are really part of our team. And that might be a nurse care manager, a lien resolution specialist, experts, as well as a structured settlement specialist. So we are going to touch on timing and why timing is important, and when do you bring in these other members of the team to counsel and guide you as well as your clients. So where I'd like to start today is with challenge number 5. And really, this is where we start at the beginning of every case, because it's important as attorneys for us to be able to clearly identify who is the client. Now, there are 3 scenarios that we're going to explore. The first one being when the plaintiff is a minor, a baby or a child under age 18. The second, when our plaintiff is an adult who's incapacitated. And the third, where our plaintiff is not the injured party because they're deceased, but is the fiduciary acting on behalf of the deceased party. So let's start with an overview about when the minor is a plaintiff. So as we all know, in Florida, 18 is the age that we set to separate minority from majority. So anybody under age 18 by law cannot approve a settlement, cannot receive or own or hold assets. Now, we do have a statute that allows a parent, and we call them the natural guardian, to settle a case if the amount involved is $15,000 or less. But you're probably going to have more cases where the amount is greater than 15,000. So we do need to open a guardianship for a minor child, but it will only be guardianship of property. It will not be guardianship of person, because the parents themselves are considered natural guardians of person. They, by law, get to make the decision about medical treatment, school, things like that. So we only need guardianship of property for a minor under age 18. Now let's talk about timing. When should you be calling me and asking me to work with your clients, the parents, to open the guardianship? I would say that once you've established with your nurse expert or whoever's reviewing the case that there is a valid claim, you've identified the insurance that is available, and you're proceeding with your discovery, I would say at that time that's the right time to open the guardianship. Now, for a minor, there is much less process in the courts that we have to go through compared to an incapacitated adult. So we do file the birth certificate to prove minority. What might come up is if you have a situation where perhaps the parents are not married, or perhaps paternity has not been proven, and so the only parental name listed on the birth certificate is the birth mother. We might need more time to address an issue like that. So it is important, and here's a practice tip, it is important when you're first retained to inquire about the other parent. and to ask and to see, of course, the birth certificate. Is that second parent's name on the birth certificate? If not, find out if that other parent is voluntarily or based on court order providing support. Those are issues we're going to have to look into. Let's say we don't have any complications. From the time that the pleadings are filed to open a guardianship for a minor, we can get a hearing and probably get the guardian appointed within 2 weeks. Again, barring a judge being out on vacation. So that's probably the easiest of the three situations. An incapacitated adult has more steps we have to go through because in the eyes of the law, every adult over age 18 is presumed to be competent, and we must prove by evidence that the individual lacks capacity, either lacking capacity to make financial decisions or lacking capacity to make medical decisions, or perhaps both. So let's say we have an injured plaintiff with a traumatic brain injury. It may be very likely that as a result of the traumatic brain injury, you have a plaintiff that is not able to understand the various options throughout the lawsuit, may not comprehend and be able to reason and make an informed decision regarding settlement. So in this case, I would suggest starting as early as possible. And here's why. We have due process safeguards built into the guardianship code, which is Florida Statute Chapter 744. When we file a petition to determine incapacity, it's going to trigger the court and the clerk of court to take the following steps. First, the clerk is going to, through a blind rotation basis, appoint a court-appointed counsel to represent the alleged incapacitated person. Their job is to go out and meet with their client and determine whether or not there is a valid basis for the petition to determine incapacity and whether the client wants to fight the petition and object. The next thing that the clerk of court is going to do is to appoint a 3-person medical examining committee. That committee can be comprised of a medical doctor, a psychologist, psychiatrist, sometimes a social worker, a physiatrist, or a nurse. And they will go out at separate times using their experience, their background, their training, and evaluate the alleged incapacitated person. They are required to complete a court-approved form that will tell the judge what are the areas in which this person lacks capacity and what are the areas in which certain legal rights should be delegated to a guardian. For example, that might include the right to marry, the right to vote, the right to determine residence, the right to make medical or mental health decisions, the right to make financial decisions, as well as the right to sue or to be sued. So we go through this process, and the clerk will schedule a hearing date 4 weeks later in front of a general magistrate. At that hearing, I will need to present witnesses and evidence to prove that the alleged incapacitated person lacks capacity in certain legal areas. If opposing counsel, the court-appointed attorney for your client, is going to object, it may then become an adversarial hearing that may require more than the standard time allocated. At the end of the hearing, the magistrate will complete a report with their findings and their recommendations, which then gets sent electronically to the judge. At this point, the judge may either adopt the findings and the recommendation if the judge feels that by clear and convincing evidence, incapacity has been established, or the judge may decide to hold a hearing, him or herself. Assuming that the judge adopts the findings and the recommendations, we can expect signed letters of guardianship within approximately a week, maybe a week and a half at the latest, from the date of the incapacity hearing. So to give you a clear time frame from the time the pleadings are filed to the time we get a guardian appointed, we're looking at approximately 5 to 6 weeks. So you're going to need to then file a substitution of party plaintiff once we get you the certified letters of guardianship. What if we have the injured party who has passed? They did not survive the accident or the injury. So we then need to open a formal administration, which is a probate proceeding where the judge appoints a personal representative, a fiduciary. And that is the fiduciary you will need for your complaint to have a valid party plaintiff. Similar time frame is involved, as we talked about a minute ago, with an incapacitated adult, although we don't have an examining committee, we don't have a court-appointed counsel. But we do need to take the time to learn from the closest family members of the decedent whether the decedent signed a last will and testament or died intestate. Now, it is a much easier process if we have a last will and testament than if it's an intestate situation, because when we get into intestacy, we have to look into whether there are any potential heirs that may not have survived the decedent. And so we have to explore if this person was married, if they were their children, were the children born of this marriage or from a prior relationship. There are different intestacy statutes that determine the amount of inheritance for each beneficiary. So we need to take the time to carefully do that investigation. Why it also takes a little bit more time in an intestate versus a testate situation is the judges require all heirs in an intestate estate to sign a very detailed affidavit that lays out essentially the family tree for the decedent. So we have to explain to these heirs that they need to be truthful, that supporting documentation such as birth certificates, marriage certificates, and death certificates must accompany the affidavit. And so it can, in an intestate situation, take longer for us to be able to have all the information to prepare the petition for administration and file it. But once we do, many judges will not require a hearing. They will allow the order and the proposed letters of administration to be submitted electronically. And then once those are signed, we can provide a certified copy to you so that you can proceed to file the complaint. So here is a best practice tip. If you are lucky at the time of being retained to have a client that you feel is competent and can retain your services, I recommend you ask that person whether they have a durable power of attorney. The reason you want to ask this question is we want to be thinking ahead that should anything change with the health or the cognitive state of your client, that will not delay the progress of the litigation. It is a very important investment to make at the beginning of the litigation because it's going to help you and the plaintiff avoid a time-consuming and a costly guardianship down the road. It's going to enable your client to maintain privacy in their life so that any decisions that need to be made financially can be done by the agent named in the durable power of attorney. And most importantly for you is you want to avoid delay in advancing the litigation and being able to perhaps settle the case at a mediation. So challenge number 4 is the question, have you asked your client whether the client receives government benefits? Why is this important? Well, this is important for a few reasons. Number 1, it might be that your client at the time of the accident was insured, but insured through employment and then could not afford the COBRA premium, so the insurance lapsed. And now they may find themselves without health insurance, and they may need, based on the injuries, to apply to the state of Florida for one of the many Medicaid programs. That's one possibility. Or you might have somebody that was uninsured to begin with. So going all the way back to 1996, the earliest case that I have found that outlines the obligation of an attorney to inform their client that a settlement or a jury verdict can impact entitlement to government benefits is the Grillo case. The Grillo case involved a young adult. The mother of the young adult had informed the attorney that her child was receiving financially sensitive government benefits. And despite that information, the attorney did not advise the mother to seek out advice from an experienced elder law attorney or an attorney with experience in the area of government benefits. As a result, once the settlement was received and the agencies became aware of it, that plaintiff's benefits were terminated. And as a result, the mother then sought to sue the attorney for malpractice. Another ethical landmine that you do want to avoid is if a plaintiff who is receiving financially sensitive government benefits asks you to somehow alter the allocation. They might say, well, I borrowed money from somebody in my family, or somebody paid my rent. I want you to give them the money. You do not want to do that. You're walking into a landmine. And there is an actual case from 2000 in Florida. It's the Dury versus State of Florida case, where there were 2 plaintiffs injured in the accident. The attorney represented both plaintiffs. One plaintiff was a Medicaid recipient, the other was not. Now, with awareness of that Medicaid should have been notified, the attorney for the plaintiffs allocated more of the proceeds to the non-Medicaid plaintiff than to the Medicaid plaintiff, and got caught and was charged criminally. So these are things you want to be aware of, and if you hear them, this is the time to explain to the client, I cannot do that. That's an ethical violation. And there are legal options. You need to get advice on what those options are to help you maintain your government benefits and preserve your settlement proceeds. And all of that can be done with transparency and is legal. So for my next best practice tip, I suggest that you add to your intake process the following question. Are you currently receiving or applying for any of the following? And you'll list out Medicaid, private disability, supplemental security income, Social Security disability income, food stamps, and HUD housing, which is also known as Section 8 housing. So let's walk through each one of these. Medicaid, the first one, is one of the most important financially sensitive government programs, meaning to qualify, an individual has to have low income and low assets. Private disability, however, is not really a financially sensitive program. It's not run by the government. It's a private insurance that either an individual might get as an employment benefit, or perhaps the individual took out a private policy. It is not based on income or assets. However, what I have seen is if the injured plaintiff also qualifies for Social Security disability income, then the insurance company is going to reduce the private disability monthly benefit by the amount of the Social Security disability. The third financially sensitive benefit is known as supplemental security income. Sometimes it's abbreviated SSI. This falls under the Social Security Administration, and it is both income and asset based, very similar to Medicaid. So if it turns out that your injured plaintiff did not work long enough to be entitled to Social Security disability benefits, they are likely going to have their application reviewed and then approved for the SSI. So this is a program we want to watch out for and be aware. The fourth program, another Social Security program, is called Social Security Disability Income. The acronym is SSDI. Now, this is not, and I repeat, not income or asset based. What it is based on is the individual having a qualifying disability that prevents them from being substantially gainfully employed or is expected to lead to death. The second prong of qualifying is that the individual must have 40 payroll tax quarters. That equates to 10 years of working and being paid on the table as opposed to being paid cash under the table. So a person can be a millionaire and still potentially qualify for Social Security disability benefits. Number 5, food stamps, falls under the Medicaid program, and this does have an asset and an income requirement to it. So it's financially sensitive and we want to know about it. And last but not least, number 6, HUD housing is also a financially sensitive based program in order for an individual to receive housing with a lower monthly rental requirement. Challenge number 3. What do we do and what do we have to be aware of if you feel that derivative proceeds should be allocated either to a spouse of the injured plaintiff or perhaps to a child, or we could have the reverse where the injured person is the child, the minor, and you're considering allocating derivative proceeds to the parents of the minor. Well, in government benefit law, there exists a concept that is called deeming. Now, deeming only goes from spouse to spouse, and when I say spouse, they must be legally married. Legally married does not mean they had a religious ceremony only, or a civil ceremony, or they are domestic partners. They must be legally married. So that's one instance in which the concept of deeming applies. The other concept of deeming applies from a parent to a minor child. And deeming simply means that the law presumes that some portion of income and assets is either going to be used for the spouse or is going to be used for the minor child. So we have to be very aware of this, because not only may we have to create a plan for the injured plaintiff to not lose their government benefits and preserve the settlement, we have to know if the spouse perhaps is receiving financially sensitive benefits as well. So we do want to ask at the very beginning about marital status. And it's a minor, we want to understand how the parents are impacted as a result of the injuries to the child. So that leads us to the next best practice tip, which is to incorporate in your intake form a second question, which would be worded as, is your spouse or minor child currently receiving or even applying for any of the following programs? And again, these would be the same programs that we just discussed a few minutes ago. Having this information in the very beginning of representation is so crucial. I find that when working with people that have been through a horrific traumatic event and their immediate family members, that they are overwhelmed for many reasons. They're overwhelmed because of the care needs that now exist. They're overwhelmed because of the strain or the stress that might be placed on the relationship, whether it's a marriage, whether it's a sibling relationship, or a parent and a child relationship. And so people may only hear a portion of what you and I counsel them about. So I like to be able to talk to the client early, where there's time for them to digest what I've recommended, make an informed decision, and not feel that they're either being rushed to make a decision or that they don't understand their choices. So if we start earlier with a consult, it gives people time to absorb the information, to come back and say, I want to talk more about this, or I didn't understand this aspect. Can we talk more about it so I better understand my choices to preserve my settlement proceeds? And I think then we end up with a client that truly makes an informed decision. Now, things can change. So we're talking about doing this in the beginning of the litigation, but it could be months later. It could be at the end of the first year of the litigation process that the client or the immediate family applies for government benefits. So my suggestion is that your associate or perhaps your paralegal that's on your team reach back out to the client and ask these questions. And we always have to be careful about how we ask things, because people can take things very literally. And so we, based upon a client's level of comprehension, based on their level of education, we might have to tailor how we say something so it's as clear as possible for each client. I also suggest that you put this in writing and send it to the client. Ask them to complete it, sign it, and send it back. That way, at each stage of the litigation, for example, when you're approaching the end of discovery, or perhaps you're preparing for mediation, your associate or paralegal goes back to look at this in the file before you step into mediation, so you're aware if there are potential liens and issues about preserving settlements. Challenge number 2. What are the options to help the client maintain government benefits and protect settlement proceeds? So my first piece of advice is that there is no one solution that fits all clients. Just like we all don't like the same flavor ice cream, we all don't fit into the same size t-shirt. A solution truly should be tailored to the current needs and the future anticipated needs of the client. And that's going to depend on many factors. Marital status plays a role. Age plays a role. What benefit programs is the person receiving? Are they able to perform some activities of daily living, or do they require full assistance? Is this person able to stay in a private residence with care, or does the person need to be in some care facility, whether it's assisted living, memory care, or perhaps skilled nursing? All of that plays a role in my making a recommendation as to what would be the top 3 solutions that best meet the needs of the client. So, for example, part of a solution might include a structured settlement with some cash. Why do I say with cash? Because we need to think about what are the things that this plaintiff has gone without during the pendency of the lawsuit. I sometimes refer to them as big ticket items. It could be a handicap equipped van. It could be purchasing a home with a generator. We have to start to think about those things that are going to be immediate purchases and estimate the cost involved so that those needs get taken care of first. With that, and it's not like we're choosing one from column A, one from column B, we're to the exclusion of the other. Many times options work together in collaboration. So if we do a structure, we might also create a special needs trust and have that structured settlement pay into the trust, not pay directly to the plaintiff, because then it's going to count. And if they're receiving SSI, Medicaid, food stamps, or Section 8 housing, they're going to lose those benefits. Depending on the age of your client, depending on the amount of the net proceeds, is going to determine, do I recommend a special needs trust, which is prepared just for this client, where they have to be under age 65, or am I going to recommend a pooled trust, one that can be used for a plaintiff of any age, but where there is one trust and multiple individuals participate by signing a joinder agreement in that pooled trust, which is managed by a charitable organization. So, for example, let's say we have an individual under age 65 and it's at least $1 million net recovery to the plaintiff. That may very well justify what's involved to prepare a special needs trust and to have a corporate trustee manage it. But if the net recovery to an individual under age 65 might be, let's say, $100,000, it might not justify creating a special needs trust. And we're not going to find a corporate trustee that will be willing to accept the responsibility and liability that comes with administering a special needs trust. And so we have to be careful, because sometimes appointing a family member as trustee is not the best decision. If that person doesn't have a financial background, doesn't have a background in investing, they may not pay attention to the rules of the government benefit programs, and they could make a mistake in making a distribution that is not allowed, and that would then directly impact entitlement to the government benefits. So all of this has to be explored. Sometimes, again, depending on the individual, we might do structured settlement with some cash, special needs trust, or pool trust with it. And perhaps we put some money into an ABLE account, which the injured individual can not directly access, but request distributions for certain qualified disability expenses. And we tend to use the ABLE account more with a younger individual that perhaps is either capable of working part-time, maybe they're in a work training program, or they want to be more involved in the decisions, the financial decisions that impact them. And then, of course, we always explore what type of exempt resources can be purchased with the settlement proceeds that don't count in the eyes of Medicaid and SSI. Even though we know they have a value, they're exempt. And so that's another planning option that we explore along with all the other options. So one of the other things we have to ask as we're looking at the age of our client is, does this person receive Medicare? Now, Medicare, as you know, is different than the Medicaid agency, although the names are very familiar. If your client is 65 years or older, the likelihood is your client has been receiving Medicare benefits. But what if your client is under age 65? Does that mean they automatically aren't getting Medicare and you don't have to pay any attention? The answer is no, because if your client is receiving Social Security disability insurance due to the injury, then within 2 years of being approved for SSDI, they will automatically receive Medicare Part A. So you have to watch, you have to be careful. Age is not the only indicator here. You also want to be asking your client, have you applied? Maybe they haven't been approved yet, but have they applied for SSDI? So it's really important to identify these issues in the beginning so you're informed, the client is informed about what Medicare's rights are as a secondary payer and whether the client is going to need to allocate some of the net proceeds into a Medicare set-aside arrangement. So a new practice tip, again, something for you to add for your intake process, is to ask a new client, are you receiving Social Security disability income? And if yes, ask them to provide a copy of the Social Security notice that approved them for benefits. Even if they got a denial, you want to see that notice because perhaps your client has hired an attorney specializing in Social Security disability law who might be appealing the denial. So that's the next question we want to ask on the intake form. But it doesn't stop there because Social Security over recent years have created just a few narrow exceptions to that 2-year waiting period for people that are approved for Social Security disability insurance. The first exception is if the individual has been diagnosed with end-stage renal or what is known as kidney disease. So if that is proven in the medical records, they do not wait 2 years, they get Medicare immediately. The second narrow exception is if the client has been diagnosed with Lou Gehrig's disease. Again, they will not wait the 2 years to receive Medicare. They will receive Medicare immediately. So it's a good idea to also, with this question in your intake, ask the client to provide a copy of their Medicare card that they will have received in the mail. Okay. So let's say we have a client who is receiving Medicare. They might be over age 65. They could be under age 65. Then the question arises, what needs to go in a Medicare set-aside arrangement and what kind of arrangement should it be? Well, here's where you probably want to work with an experienced nurse care manager who is familiar with the Medicare reimbursement policy of the agency. They will be able to look at the life care plan and pull out those items that otherwise Medicare would pay for. because that is going to help them tell you and the plaintiff how much money from the settlement needs to be allocated for a Medicare set-aside arrangement. Now, there are a couple of options. One is that the client can simply open a bank account for the Medicare set-aside, or an attorney can actually write a Medicare set-aside trust agreement, and then an account would be opened. If your client also is receiving Medicaid or SSI, and we're creating a special needs trust, then we're going to write the Medicare set-aside trust underneath the umbrella, so to speak, of the special needs trust agreement. Depending on what's involved, meaning how much money has to fund the arrangement, depending upon the cognitive abilities of your client, really is going to determine who should be administering the Medicare set-aside arrangement. Because this is not something that you want the client to make a mistake on. Otherwise, they may go to a doctor's appointment and be told when they're checking in that the doctor will not see them because the Medicare website is saying that the client's Medicare has stopped. So do consider having a professional administer the Medicare set-aside arrangement for your client to avoid that problem occurring and you getting a call from the client saying, "What happened? I couldn't see the doctor. I don't have Medicare anymore." Now, there are two very narrow exceptions to the requirement of an MSA. We always start with, do we have to consider Medicare's interest? And that's answered by both the age of the client and whether the client is receiving Medicare, has applied, or is appealing Medicare. But an MSA is not required if the settlement is not going to compensate the plaintiff for future medicals, or the plaintiff's treating physician in writing gives the opinion that the plaintiff will no longer need Medicare covered services relating to the injury. Now, there is a specific memorandum on the Medicare website it is found under the workers' comp page. And I suggest that you keep a copy of that memo in your file so that if you're lucky enough to have this set of facts, you can demonstrate that you considered Medicare's interest and the MSA is not necessary. I do suggest that you sign up on the Medicare website to get updates, to get emails whenever there's any new developments, whether it's under the workers' compensation MSA portion or the non-group health plan recovery, which applies to liability insurance. So we finally arrived at challenge number 1, which is setting realistic expectations for our clients. And I would ask all of you to be very careful what you say, because clients will remember it and they will take things literally. And if you start promising them the sun, the moon, and the stars, and you don't know the government benefit rules, then by the time they meet with me, they're going to feel that I'm giving them conflicting information. And then they question, well, what am I supposed to believe? So it's important that we work with a realistic life plan, cost plan, that we have a cost analysis done. And I actually encourage all of you, when I do meet with your client, to be present. You don't have to necessarily participate, but just to understand the process as well as the information being provided. That's really the ideal time to start bringing in other team members so that the client has accurate information and they understand how everybody on the team is helping to shepherd them through the process. So, it's nice to have, what our parents might have called extras as opposed to necessities, but everything has to be balanced. And we want to do our best to ensure that these proceeds will hopefully last the lifetime of the client and that the client is not going to outlive their proceeds due to irresponsible spending. So I hope the takeaways for you today is that it's a win-win situation for everyone taking the team approach. It allows you to be better informed, avoid legal malpractice, be the knight in shining armor who provides value-added service to the client, and having that timing working out makes it easier for you for the transition process and for the client so that we have time to assess the client's capacity, learn and appreciate what the client's needs are, work with you to understand the liens and are there possibly any exceptions to Medicaid lien recovery, and to counsel all involved. So I appreciate you joining me this morning, and please reach out to me. I look forward to working with all of you. Have a great weekend.